All the people out there in the internet world that are joining us by live stream or whatever, you can sit back and listen to the colloquy just like everyone else is going to hear. All right, if you're going to appear in front of me today, if you have the physical ability, please stand and raise your right hand.
One's in the wheelchair, just sit up.
If you're in a wheelchair, stay.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, please have a seat. Please listen up. You're here for your initial appearance. Each person that is arrested is entitled to see a judge within 24 hours of their arrest. There are three purposes for our hearing today. First, to determine probable cause for your arrest. Second, to make arrangements for an attorney. Third, to set bond and release conditions. Your next court date will be on the paperwork you receive after you appear in front of me. As to our first purpose today, that is probable cause for arrest. That means whether there is reasonable grounds to believe that a crime has been committed and you're the person that committed that crime. If I find a lack of probable cause, that gives me two options. First, I can release you ROR, or second, I can give the state up to 24 more hours to prove up that probable cause. If you're released for lack of probable cause, it just simply means you're released from custody for the moment. It does not mean your case is over. The state is still entitled to file those charges and pursue them against you. As to our second purpose today, arrangements for an attorney, when I ask you, what are you going to do about an attorney? There are three answers to that question. First, I'm going to hire my own attorney. Second, I cannot afford to hire my own attorney. I wish for you to appoint me the public defender or a court-appointed attorney. Third answer is I'm going to represent myself. That is not a good idea because you're already incarcerated and you're facing possible future incarceration, so representing yourself is probably not a good idea. So if you make a request today for the public defender, I will appoint the public defender. That means that there would be a $50 application fee added to your case, and then when your case resolves, the public defender may ask for a lien that would be added to the fines and court costs you may be required to pay. As to our third purpose today, bond and release conditions, sometimes when you go through booking, bond's set too high, sometimes it's set too low. I'll set a reasonable bond and release conditions. Everyone that appears in front of me will get at least three release conditions. They are, number one, you're not to possess or consume alcohol or illegal drugs. Second, you're not to possess weapons, firearms, ammunition, or drug paraphernalia of any kind. And third, you'll be subject to a curfew from 10 p.m. to 5 a.m. I may set other release conditions depending on the crime with which you've been charged. If you're here on a warrant, whether it is for violation of probation, arrest warrant, or a failure to appear bench warrant, the judge who signed that warrant has already determined your bond amount, and you'll need to go in front of that judge to modify that bond amount. You do have the right to remain silent under the Fifth Amendment to the United States Constitution. So I caution you, do not talk about the crime itself. Everything in this courtroom is being recorded, and a recording could be used against you in a future court proceeding. So let me say it again. Do not talk about the crime itself. I may ask you questions of an administrative nature. You always have the right to refuse any questions I may ask. You also have the right to communicate by telephone with your attorney, family, and/or friends.